प्रोवेट और लेटर ऑफ एडमिनिस्ट्रेशन के बारे में जो इम्पोर्टेंट मैटर्स है, जो फंडामेंटल बैकग्राउंड्स या कंसेप्शन के लिए ये पॉइंट लिखा गया था. प्रोवेट कोर्ट इज नॉट ए कोर्ट. It is a designated authority under the special statute named as Indian Succession Act 1925. This act is intact till now. No amendment has been introduced in this act. It is a substantial law which also contains some procedural provisions. Prior to this act, there were 15 acts relating to will, testament, probate, and letters for administration. But all those acts are now not in existence, and their relevant provisions have been incorporated in the Act of 1925. Designated authority under the Indian Succession Act 1925. The only designated authority under the said act is district judge. The word district judge has been defined in this act, section 2BB. It has also been defined in General Clauses Act, Bengal, Agra, Assam Civil Court Act 87 and the Constitution of India. For the purpose of this act, district judge includes additional district judge. Like any other civil matters, the cases arising out of this act are being filed before the district judge, who has got original jurisdiction to try the testamentary cases. He may either try himself or transfer the cases to the ADJ. After such transfer, the ADJ shall proceed in the matter as if he is a district judge. But in the order sheet or any order or judgment, he shall sign as ADJ, not as DJ. Apart from district judge, there is a provision for appointment of district delegate in the terms of section 265 of the Act, for which High Court is empowered. Any judicial officer subordinate to district judge, namely Munsif, sub-judge, may be appointed as district delegate. In Bihar, Munsifs have not been empowered as district delegate, but in other states, Munsif have also been empowered as district delegate. If any case is filed before the district judge and he considers that there is no contest in the matter by any party, then such case shall be considered as non-contentious case. Here, case means case arising out of a petition filed for grant of probate under section 276 of the Act, or a petition for grant of letters of administration under section 278 of the Act. There are other provisions under the Act giving rise to different nature of proceeding before the district judge, just like appointment of curator, administrator, receiver, and delivery of possession on the properties involved in the proceeding for grant of probate/LA. If the district judge finds that the case is non-contentious for want of any opposition by any party, then he, instead of trying the case himself, transfer the same to the district delegate, who shall decide the case just like ex parte proceeding. But the district delegate does not become district judge in relation to such contentious proceeding, nor he remains as sub-judge or munsif. Therefore, in every order or judgment, wherever signature will appear, his designation will be as a district delegate only. There is no provision in the Act to file direct case under the Act before the sub-judge or munsif or before the district delegate. In case any petition under the Act is directly filed before the munsif, sub-judge, district delegate, he shall not proceed in the matter except to return the petition for presentation before the district judge. Otherwise, any step taken or order passed by the district delegate, sub-judge, munsif shall be without jurisdiction, null and void. If there is no appointed district delegate by the High Court in writing, then the district judge has no power to transfer the case to sub-judge, munsif, treating them suo motu as district delegate. There is a provision for grant of succession certificate under the Act, for which the original jurisdiction is vested with the district judge only. But the state government has power to designate judicial officer of any rank inferior to the district judge to deal with the cases of succession certificate in terms of section 388 of the Act. If there is no such notification, then no judicial officer inferior to district judge can entertain any petition for grant of succession certificate. The succession certificate is being granted under Chapter 10 of the Act, and the petition for the same is being filed under Section 372 of the Act. Thus, ordinarily, the district judge is the only authority to deal with the case in respect of succession certificate, which he either himself decide or transfer to ADJ. But by virtue of notification issued by the state of Bihar and published in official gazette, such power of district judge is being vested directly to inferior judicial officer like sub-judge. Hence, such judicial officer ipso facto becomes district judge for that purpose. But his designation shall not change, rather his act will be just like a district judge in discharging judicial function in his own name and designation. Therefore, such empowered inferior judicial officer shall have power to entertain application directly and to dispose of the same in accordance with law. क्लियर है सब लिखा हुआ. A petition for grant of probate oblige letter of administration. It is simply a petition. Hence, it is registered as probate case, LA case. In High Court, it is registered as test case. There is no opposite party, defendant. आप लोग पढ़िए, आपस में बात कर रहे हैं, पढ़ते जाइए. आप सुनते भी जाइए और देखते भी. There is no opposite party, defendant or respondent in the probate oblige LA proceeding, which are not sued. For reference, in the petition, it is mentioned as in the state of decease so and so. The requirements for filing probate is mentioned in section 276 of the Act, whereas the LA in section 278. No other facts are required to be mentioned in the petition, but there is no bar to mention any material facts beyond those sections with a view to establish the claim of the petitioner. Every petition must be verified and affidavitted by the petitioner in accordance with the provisions of CPC for verification and affidavit of pleading, section 280. Apart from such verification and affidavit, at least one attesting witness must also verify the petition and support with affidavit, section 281. If no attesting witness is alive, then there must be a specific and categorical statement made in the petition itself regarding death of such witness. कल सवाल पूछा गया था मरे हुए के बारे में. There is no need to mention description of the properties under will in the petition for probate obligale. However, if such description is given in the petition, there is no wrong. Petition में property का list देना भी जरूरी नहीं है. If the description of the property is either mentioned or not, but in every case an inventory is required to be filed with the details of the properties along with its valuation supported with affidavit. Otherwise, the petition shall be immature, and in the absence of the same, the original petition may be rejected as non-maintainable. Such inventory is required to be filed under section 19I of the Court Fees Act. इसी के हिसाब से court fees दिया जाता है. At the time of filing of the petition, a stamp for general petition in civil court is required to be filed. After filing of inventory and valuation, the district judge shall call for report from collector of the district regarding valuation of those properties, and on receipt of such valuation report, the probate duty is to be decided under the Probate Duty Act, which is on ad valorem basis just like court fee as contained in the Court Fees Act. At present, the maximum probate duty is 3 lakhs, but by a state amendment, which has been stayed by the High Court, due to which the maximum limit 30,000 is applicable. Duty money is deposited in Nazara through Challan, and deposit receipt obtained by the petitioner is required to be filed in the court. Then the court shall proceed further. Thereafter, the Nazi shall procure the non-judicial stamp for treasury from treasury and submit to the court, upon which, at the final end of the proceeding, probate oblige alias shall be issued on the same stamp paper. No notice or summons is required to be issued as prescribed in CPC, because there is no defendant and probate proceeding is not a suit. However, under section 283 subclause C of the Act, citation is being issued, which is called a general citation. There is no need to mention the names of any near relatives or deceased testator in the probate petition. That is why it is necessary to issue citation through all 3 modes as mentioned in section 283 of the Act. Whereas in the LA petition, it is necessary to mention the names of near relatives of deceased testator. If the name of near relatives have been given in the LA petition, then it is necessary to issue individual citation against them. Original will should, ये जानना जरूरी है. Original will should have to be filed with probate oblige LA petition. If original will has not been filed with probate oblige LA petition, then it is necessary to give direction to the petitioner to